Welcome once again to Lehto's Law. Here's Steve Lehto.
Aaron sent me a brief note yesterday, said, Steve, check out this order from a federal court. And I read the order. It's 3 pages long. And it's the kind of thing that sends chills down your spine if you're an attorney. But the case is actually not important in the sense that you've never heard of it, I've never heard of it, and we'll probably never hear of it again. But what happened was the attorney for the plaintiffs submitted something to the court. And the court has a bit of a problem with that. And so I'm going to tell you what this is. It's out of the United States District Court for the Southern District of Texas, Houston Division, Civil Action 4-24, CV 0639. This order was filed and entered with the court on February 18th. Case is called Dawkins. And it's a show cause order. A show cause is where the court orders someone to come in essence, and explain themselves. Explain this, okay? So pending before the court is the defendant's motion to dismiss and for sanctions against plaintiff's counsel. The plaintiffs filed a first amended complaint and a response. The defendant then filed a reply arguing that the first amended complaint also fails the Rule 12b-6, and again moving for sanctions. Upon reviewing this and similar cases, the court is faced with several facts that raise major concerns. On April 5th of last year, the defendant filed a motion to dismiss and for sanctions on plaintiff's counsel for filing a frivolous lawsuit. Shortly thereafter, presumably to rebut the accusations of frivolousness, plaintiff's counsel filed an affidavit from a designated expert stating that the expert had appraised the plaintiff's home on May 31st, 2023, and found actual damage. And this case is involving an insurance claim. We can deduce that from these facts, okay? So, complicating things for plaintiff's counsel is the fact that that expert died almost a year earlier in June of 2023. But the affidavit was signed by the expert on April 25th, 2024. So plaintiff's counsel apparently submitted to the court a signed affidavit that was notarized, and it was supposedly from an expert, but the expert had died a year earlier. And in fact, the expert died almost a year earlier after an allegedly difficult battle with brain cancer. Now, you might go, Steve, why did they include the brain cancer thing? Well, this is a fact known to plaintiff's counsel since at least December of 2023. The court was presented with evidence that plaintiff's counsel learned of the expert's death in December of 2023 at the very least. Plaintiff's counsel has been previously sanctioned for relying on expert opinion from this expert without this expert's knowledge. And then the court cites a case. In that case, the expert stated in a deposition he had never been asked to serve as an expert and did not write the report that counsel claimed he had. Following the trial court's sanctions there, counsel was quoted by a news outlet saying something to the effect that the trial judge was corrupt and that when the expert made those statements, he was delusional because he was in the final stages of brain cancer. And then the court cites a couple articles here that were in the news, in the Houston Chronicle and in claimsjournal.com, for instance. So consequently, counsel knew that the expert was chronically ill and delusional by January of 2023. Nevertheless, counsel designated the same expert as testifying expert in this case in May of 2024. So if a year and a half earlier he was delusional and you're using him now, in his pleadings before this court, counsel alleged that the expert, while apparently delusional and dying, according to counsel's prior statements, performed an inspection and appraisal on May 31st, 2023, 2 days before his death. Further, counsel filed a sworn affidavit allegedly signed by the expert before a notary public on April 25th, 2024, approximately 10 months after the expert died. Federal Rule of Civil Procedure 11B states in pertinent part that when a lawyer files a pleading or declaration, the attorney certifies that it is not being presented for any improper purpose, such as to harass, unnecessary delay, or increase the cost of litigation. The claims, defense, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. The factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery, and the denials of factual contentions are warranted on the evidence, or if specifically so identified, are reasonably based on a belief or lack of information. Federal Rule Civil Procedure 11B clearly, and this is the court now writing, filing an affidavit purportedly signed by a dead man violates both the tenor and text of Rule 11. This is especially true since this does not seem to be the first time something similar has happened. Based on those facts, it seems that plaintiff's counsel has knowingly falsified or at least filed a falsified sworn affidavit for the purposes of deceiving the court. Also at fault would be the notary public, who notarized and swore that a dead person signed an affidavit 10 months after the affiant's death. So the attorney is being called to task here, as is the notary. As such, counsel is hereby ordered to show cause, and they include a date here in March, as to why, 1, the case should not be dismissed with prejudice. Unless you got a really good reason, it's getting dismissed. 2, Rule 11 sanctions should not be imposed on plaintiffs or their counsel. And so Rule 11 is harsh. It says that the court can sanction parties by making them pay fines. And they can sanction the parties or their attorneys or both. 3, show cause why counsel should not be referred to the State Bar of Texas for a formal investigation and possible disbarment. 4, counsel should not be referred for disciplinary action in the Southern District of Texas, where the court could discipline them, the actual district, not just the judge. 5, the notary public should not be reported to the appropriate state officials. And 6, counsel should not be referred to the United States Attorney's Office for a review of potential charges of perjury and wire fraud. So I know that's written in the negative, but the sentence reads, you're ordered to show cause by this date as to why these things shouldn't happen. Okay? And so, one is the case is going to get dismissed. It's really, really hard to explain why the case shouldn't be dismissed when the expert you're relying upon died and somehow managed to file an affidavit from beyond the grave. That's going to be a hard hurdle to clear. 2, sanctions against the plaintiffs and their counsel. Here the real question is, do the sanctions go against the plaintiffs or their counsel? That's the thing. Is it possible that the plaintiffs themselves cooked this whole thing up? Doesn't seem likely, considering this attorney has dealt with this expert before. Have the plaintiffs ever? But 3, you need to explain why you shouldn't be referred to the state bar for a formal investigation of possible disbarment. That right there, my friends, is where it starts getting serious. Also, disciplinary action in the Southern District of Texas, meaning that the court, the judge, can sanction him for actions in this case. The judge is saying this is so serious that I might refer it up, and the Southern District itself might take action. Now, a lot of this probably won't be necessary because some other things might take over. So if the guy gets disbarred, for instance, then they don't need to worry about whether or not he practices in this court, because you can't do that if you've been disbarred. Likewise, the notary public. The notary public, I've mentioned before, their only job is to confirm that someone's in front of them signing and they are who they say they are. So for them to notarize the signature of a dead man is going to get tricky. Now, if the notary says, hey, somebody walked into my office and said, I'm so-and-so, and handed me some papers, and they had identification, that's one thing. But if he says, or she says, no, I just had someone show up and just sign, or someone said, here, this was signed by my expert, notarize it. So the question is, did the notary follow the proper procedures? And it seems unlikely. And then finally, show cause why counsel should not be referred to the U.S. Attorney's Office for a review of potential charges of perjury and wire fraud. And that is some ugly stuff. I've been practicing law for 34 years. I've seen attorneys get show caused a few times in 34 years. It's fairly uncommon in terms of a show cause specifically about the attorney. I've heard of attorneys getting hit with Rule 11 sanctions before, and it's usually because they got a little over-aggressive, and I'm putting that nicely, in their pleadings. They pled things that they didn't have evidentiary support for, and they were hoping to find it later, but couldn't. And the question then is, well, do you get out of that exception by saying that you may or may not have evidentiary support, but you think you can have it after further investigation or discovery? And I've had cases before where somebody's come into my office and said this, 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 and this. And I go, okay, what do you got to support that? And they go, this and this. And I go, yeah, but you showed me 4 things and you've only got 2 of them supported. And they go, yeah, but I know these are true. And I go, why do you know that? And I listen to their story and it sounds reasonable. But you have to draft a complaint to reflect that. So you say this, upon information and belief, this. And so a court will often look at that and go, okay, you said upon information and belief, indicating that you're hoping you can come up with it during discovery. At the end of discovery, if you haven't come up with evidentiary support, you should probably drop those allegations. And if you don't, the other side might say, if you don't drop the allegations, you can bring a motion to dismiss, at least on those counts there. And if you've got nothing to support it and you're still fighting this, we can get Rule 11 sanctions in federal court. State courts have got a similar thing, but it's not as harsh as federal court. Federal court, trust me there, you don't play around in this stuff. So this is a situation. There'll be a hearing apparently in March, a few weeks down the road. Aaron, if you're following this, please let me know what happens on this. I'll try to make a mental note too to follow up on it. But this is not good. And by not good, I mean these allegations that the court is making here are that an affidavit was submitted to them that would keep a case alive. And the affidavit was allegedly signed by a dead man. And worse, the counsel would apparently have known the guy was dead. So it's kind of hard to explain how that could happen that way and be innocent. However, maybe there's an explanation, and that's why you got a show cause hearing. Show cause. Come on in and show me what you got going for you to explain why this bad stuff shouldn't happen to you. So it's one of the worst situations I've seen an attorney get themselves into, but we'll see what happens. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. In the middle of a difficulty lies opportunity.